Donald Trump files another motion to dismiss his case in Florida. The classified document saga, Judge Eileen Cannon presiding, and Trump submitted a whole slew of these motions, and we've covered several of them here already, including the motion to dismiss based on presidential immunity and the motion to dismiss because Jack Smith is illegitimate. We're very excited about those two working their way through Cannon's court. But now we have another one, and this one we've been paying close attention to as well. What about the Presidential Records Act? You've probably heard Trump had these classified materials, and some people say, well, maybe he declassified them, so they're not actually classified. But there's a whole nother concept. What if the president just says, those are my personal records, okay? And I'm the president, so I get to make these decisions. Somebody who's questioning me about whether these are presidential records or whether they are personal records would put them above the president, would put their discretion above the president's, which is obviously insane. But that's what they tried to do with Trump. They tried to put Nara, Deborah Steidel-Wall, in a position above Trump to say the head librarian can decide and tell Trump what is true. Presidential records got to stay with the government, but if it's a personal record, it can go with Trump. And our point here for ages has been that the president has unfettered right to access to those documents. It's in the Constitution. If they don't like it, they can change that, but they haven't done that. And any other congressional statutes that says, oh, my classified or whatever they say, I don't care. It is a statute that is subordinate to the Constitution. And if you put some other entity above the president, it topsy-turvies the whole Constitution. So now here is what Trump is saying, referencing many of these same arguments. Let's get right into it. The motion to dismiss the indictment filed in the classified documents case by Donald Trump, citing the Presidential Records Act, filed in Judge Cannon's courtroom, West Palm Beach Division, and this is United States of America versus Trump, Walt, and Carlos in Florida. Here's what they tell us. Dear Judge Cannon, President Donald Trump respectfully submits this motion to dismiss the superseding indictment because of the Presidential Records Act. Let's get into it. First, the Presidential Records Act, the PRA, it conferred to Trump unreviewable discretion to designate the records at issue here as personal. Bill Clinton can do it, Trump can do it. Now, as such, because the Presidential Records Act gives him that power, Trump's possession of those records, all those 32 documents that are in the indictment, was not unauthorized. If they're personal, they're his, they're not unauthorized. Counts 1 through 32 say it differently, but they're wrong. And second, even if there was some sort of violation of the Presidential Records Act, Judge Cannon, the PRA, if you look at the act, it's exclusive remedy for a records collection effort to go get those back from Nara, Deborah Steidel-Wall, who initiated this whole thing. It's civil in nature and it forecloses criminal investigations. So you just civilly go get this stuff back. You don't prosecute the man. Footnote 1. And they say, by the way, Trump also reserves the right to supplement this motion and add a bunch more to it if we want to. Saying, therefore, Judge Cannon, as with counts 1 through 32, and recall that each count from 1 through 32 was just a different document. Okay, that's it. So document. And many of them are briefings and, meaningless stuff. Maybe it was important on the day of the briefing. It's not important 5 years later when all the stuff has already happened and everybody knows about it. The remaining counts charging Trump then, so if counts 1 through 32, if he was in possession and they were not unauthorized, then all of the following counts about obstruction and conspiracy and all the other garbage, then it all fails to state a claim because he wasn't in illegal possession. And so accordingly, they say the whole dang indictment now gotta go. They say, all right, Cannon, first of all, the special counsel's office concedes that the genesis of this case, their own statements, it dates back to at least, quote, the tail end of the Trump administration itself. In other words, Trump was president still. The office in Jack, the illegal office, alleges that Trump, here you can see the word caused is italicized. Trump, when he was the president, caused, all right, so Trump did the bad thing, caused scores of boxes, many of which contain classified documents to be transported. He's the root person. Now, the superseding indictment from Jack also makes clear that this decision and the related transportation of these records occurred while Trump was still in office. So think about this, right? If you caused something to go somewhere, that means it's emanating from your presidential power, right? You are deciding if it stays or it goes. What do you decide, right? So we're going to come back to that. Now, they say that Trump caused boxes of records to be packed and to be shipped in January 2021 as he was preparing, okay, again, so meaning he was in the presidency, preparing to leave. So all this stuff happened as president. So President Trump departed the White House prior to 12 p.m. on January 20th. They tell us he's never going to leave again. If you elect him, it's the end. He'll never leave. Like he left last time, you weird freaks. After you just said he insurrected the country, he packed up and left. Nice. And as such, all of these allegations are decisions concerning the documents at issue while he was commander in chief. So it's all within the power of the presidency because he was in the office preparing to leave. So they give us some background here. All right, what is the status on a motion to dismiss? What's the standard? So Judge Cannon, here's some authority for you. If you want to dismiss this indictment here, you can. It says an indictment may be dismissed where there is an infirmity of the law in the prosecution. So when Jack Smith is charging a crime that's not really a crime, crime, you can dismiss it. A district court, like you, Cannon, may dismiss an indictment when immunity or double jeopardy or jurisdictional issues are implicated, and an indictment that requires speculation, you have to fill in the gaps on a fundamental part of the charge, it's insufficient. So you got to say what you're charging, and it's got to be legitimate in the indictment itself. They go back. They say, let's talk about the Presidential Records Act. They say, beginning with George Washington, presidents of the United States have, without notable exception, treated their presidential papers as personal property. We talked about that in a case called Nixon versus United States back in 1992 in Washington, D.C. In 1974, a lot of presidents take their documents. Even Washington did it. Congress, back in 1974, they enacted the Presidential Recordings and the Materials Preservation Act of 1974 because they were based on a concern that Nixon might destroy records related to Watergate. The controversy over Nixon's records and whether the act interfered with his right to privacy in his personal records led to the passage of another act, the PRA. So some history on that, right? Nixon, Watergate happens, Congress says, oh, this dude deleted a bunch of recordings out of the White House. That's not good. So they pass the first version, Presidential Recordings and Materials Preservation Act. They're like, wait, that's way too overbroad. It's going to gobble up everything from the president. So Congress modifies that. 4 years later, 1978, boom, we get the Presidential Records Act that we live with now. Now, in passing the Presidential Records Act, Congress, this is from a case called Armstrong versus Bush in the D.C. Circuit 91, says when passing the Presidential Records Act, Congress was also keenly aware of the separation of powers concerns that were implicated by legislation regulating the conduct of the president's operations, right? Because you got to be very careful there. If Congress can just legislate what the president has to do or can do, then is Congress the president? That's why we have a separation of powers. We don't want one branch gobbling up too much power. And when Congress does that, the president tells them to get back, flexes. This is my power. So Congress, therefore, sought to assiduously to minimize outside interference with the day-to-day operations of the president and his closest advisors. Now, Congress also limited the scope of judicial review, so the courts can't dig into it, and provided little oversight authority for the president and the VP's document preservation decisions. You know, because, of course, they're the president and the vice president. Now, all that was perfectly normal until Trump came in. And they're like, well, he's only kind of the president, and he doesn't have certain things that all the others had. They say under the PRA, during a president's term in office, the president shall remain exclusively responsible for custody, control, and access to the presidential records. So when Trump's in office, it's his. The use of the word shall often denotes mandatory obligations, but what the president must do is exercise his discretion, and the rest of the text calls for exercise of considerable judgment, more case law. Now, this includes, they say, the sole discretion, meaning Trump, not Nara or Deborah, sole discretion, the law says this, 44 U.S. Code 2203B, also cited in Armstrong, says the president has the sole discretion to categorize materials as presidential records or personal records. So if they're personal records, the argument is they're not inside the scope of Jack Smith. He can't charge Trump for those. Now, they say reasoning that the Presidential Records Act accords the president virtually complete control over his records during his term in office. They continue. And this comes from a Judicial Watch case. Remember, our friends over at Judicial Watch, they sued Bill Clinton to try to get this stuff, and they protected Clinton. They said, well, if it's his decision, he's the president, you know. The PRA does not confer any mandatory or even discretionary authority on the archivist to classify records. Oh man, Deborah's not happy about that. And she's the one who started this whole thing against Trump. So there's no discretionary authority to decide for them what's presidential or personal. No, the responsibility is left solely to the president. Upon conclusion of the president's term of office, the Presidential Records Act, 44-2203G, when the president's done, at the conclusion of the president's term, the archivist, in this case Deborah, quote, shall assume responsibility for the custody, control, and the preservation of and access to, look at this, the presidential records of a president, not the personal. So president, when he's done, he splits his books. These are my personal stuff. Those go with me to Mar-a-Lago. These are presidential records. Put those in your archives, Deb. Now, NARA's responsibility under that provision, it applies only to records, quote, that were designated as presidential records during the president's term. So when Trump splits those documents up, it only applies to what he specifically marks as records. Now, thus, the PRA assigns the archivist at NARA no role with respect to personal records once the presidency concludes. It's done. You're done. Now, courts may review guidelines, okay, outlining what is or what is not a presidential record to ensure that materials that are not subject to the PRA are not treated as presidential records. Again, bunch of case law here. And they say here, in this case, this one considered judicial review, so whether the court was reviewing it. This case says, if you consider judicial review of policies and guidelines that exclude from the reach of the presidential acts, vice presidential records, that was that case. Here's another one that's considering judicial review, and so on. But, however, a close reading this is Trump's team, of the Armstrong 2 decision suggests that the limited judicial review authorized by the D.C. Circuit left untouched another portion of Armstrong 1, so a second case came back, but it didn't impact the first case. The first case gave the president unfettered control over his own documents because it's the president. So that's some background, okay? These are the rules they say that are appropriate here and why the president has some power. And then we're going to see some more analysis and discussion as this applies to Trump. They say to Judge Cannon, all right, Judge Cannon, when we take all those rules and all those facts and apply them to our case with Trump, here's how it breaks down. First, President Trump's possession of all of the documents, those 32 documents in the various counts, it was not unauthorized under the law. Here's why. Trump exercised virtually unreviewable Article 2 executive authority to designate the records as personal, when, as alleged in the indictment, he caused the materials to physically be transported out of the White House while he was still in office. So he made the decision. Okay, he bifurcated them out into personal and presidential. President Trump was still the president of the United States when, for example, many of the documents at issue were packed, presumably by the General Services Administration, and that they were transported and delivered to Mar-a-Lago. Okay, so there were things happening while he was the president. All the things were being decided. The DOJ previously took a substantial similar position on behalf of NARA. So they cite us back to this Judicial Watch case versus NARA. So some time ago, Bill Clinton, remember, he left office and he had all these judicial records. We call them the Clinton sock drawer tapes. And Judicial Watch and Tom Fitton and those amazing people, they sued to get access to it. They sued NARA. They said, okay, you've got these documents and why don't you have these materials? You have these, and they sued. So what did the DOJ say back then when they were protecting Bill Clinton and they, didn't have Trump to worry about? So of course, they took a similar position the DOJ did when Bill Clinton was being sued. They said President Clinton, this is the DOJ, presumably classified the tapes as personal records by not transferring them to the National Archives at the conclusion of his administration. See? So a lot of people will say, well, Rob, or anybody making this argument, Trump didn't officially declassify anything. And he didn't classify them, right? We see this word classified. We are talking about classified documents, but we're not talking about classified documents. We're talking about the classification of other documents, whether those documents are personal or presidential. And some of those records may have been classified, but that's not the classification that we're talking about right now. Hopefully that makes sense. So Trump, he classified these materials, he left, and they're protecting Clinton for doing much the same thing. But if NARA has the ability to make the president fill out a form, okay, then that's essentially the president, right? Because the power to access these materials, it emanates from the Constitution. Article 2, Section 2, Clause 1, I believe, which talks about the opinion clause power, and they're emanating it. It's the separation of powers concept. Well, and let's be clear. They're saying that, remember, Trump didn't officially fill out the form, and that's why they're not declassified, why they're not classified as personal. Clinton did the same thing, okay? By not actively giving them to the archives, they by default just get automatically categorized as personal. And to have NARA or someone else come back in and override the president's discretion on that makes them the president. So this makes sense. Like, Judicial Watch made a good effort, but this makes sense, right? If they're going to hold this standard here, it should also apply to Trump. But of course they're not. They're going to change their position, the DOJ themselves. They say President Trump made the challenged designations, the classifications, while he was in office as the constitutional superior to the archivists. Sorry, Deborah. The only reference in the entire Presidential Records Act to the designation of records as personal versus presidential also calls for the decision to be made by the executive and to be made during and not after the presidency. Now, that's also from Judicial Watch. The categorization of the records during the presidency, that controls what happens next. And the statute, it assigns the archivist no role in respect to the personal records once the presidency concludes. You're done. Thus, NARA has no authority over personal records, and the Presidential Records Act does not establish property rights for the United States. Those are our materials. And they say that Trump was obstructing. No, he wasn't. They're not yours. Referencing 44 U.S. Code 2203. This is what the law says. Upon the conclusion of a president's term of office, NARA shall assume responsibility for the presidential records. They also cite the Hur report at 193. So they're referencing the Hur report. Yeah, even he says that. Says personal records remain the property of the former office holder. Those are all Trump records. So thus NARA does not have the authority to designate material as presidential records. They don't get to decide that, even though they really want to. The archivist also lacks the authority under the PRA to inspect presidential records or to survey their records management practices. That's from the Crew case. The court is left with the undeniable conclusion, they said this, that Congress vested almost no authority in Deborah, the archivist, and NARA over vice presidential records during a vice president's term in office. No authority. Couple footnotes. This is the Hur report. They say, look, even Robert Hur, he explained this when he found classified documents in Joe Biden's residence. I really like that they worked that in there. That's fun. The PRA, says Trump's team, also precludes judicial review of their record-keeping practices. So you don't get to come in here, Deb, and say, well, we don't like how you're keeping your books. It's too bad. You're not the president. Run for office. Become the president. And then you can fix that. Including President Trump's decision to designate those materials as personal. Permitting judicial review of the president's compliance with the PRA would upset the intricate statutory scheme that Congress carefully drafted to keep in equipoise, we don't hear that word often, important competing political and constitutional concerns. Because then the courts can just come in and just usurp everything, right? Judicial Watch can sue. And then Bill Clinton has to go get these personal records, got to go dig them out of his disgusting gutter drawers or wherever, and, pull those out, rinse them off, and give them back over to Congress, right? Or to NARA if they had to do this. And that's obviously, like, the presidency is a powerful position. That's it, right? That's what our Constitution says for a reason. And you can't just decide that these things no longer matter. There's a logic behind it, which is why we're seeing what has been done. Now, it would also be incongruous to permit judicial review of personal records designations in light of the fact that the president's decisions to restrict access to presidential records for up to 12 years, those are not reviewable either. And so even with respect to an incumbent president's decision to destroy records while in office, so the president could even just torch these things, the PRA provides only cautious authority for the archivist and Congress to question those actions. You want to destroy the records? Go wild. That's from Armstrong. Precedent. So therefore, courts must steer clear of efforts to supervise the day-to-day operations within the White House. Otherwise, they're the White House. Even when a complaint presents legitimate concerns about an ongoing practice that threatens the preservation of or the public access to presidential records, you still got to stay out of it. When it comes to compliance with the PRA, courts have no jurisdiction to review their day-to-day. And that structure, here we go, is rooted in the separation of powers doctrine, which stands as a key basis for our system of government and rule of law. Yeah, but Trump's an even bigger threat. So we don't need separation of powers anymore. We can just have everybody do whatever they want as long as it results in Trump not winning. And then, even though the rest of the country will be left in a smoldering ash heap of disorder where the Democrats control everything, that's okay. That's their playbook. They're happy about that. So moreover, it would demolish the notion of a chain of command, right? Because within the executive branch, if a NARA employee, including the archivist, was able to dictate to a president who embodies that entire branch of government how to handle the records. That's the point we've been screaming about here for I can't even say how long, like a broken record. Finally, I'm glad we see it in a filing. Deborah would be the president, okay? I'm sorry, Trump, you didn't get your library book due back in time. You're getting a penalty now. Criminal indictment, sorry. What? For the president making a decision about his own documents? The chief executive of the whole branch. They say, sorry, you have to follow our forms. Fill out your forms and let us know that you're declaring these as presidential records and these as personal records, and then make sure you do it by Friday. Get out of here. Ridiculous. It would be insane to do this, but this is what they've done. We have a whole criminal case being prosecuted on this basis right now. They say the DOJ and NARA have adopted this position with respect to government officials whose last name is not Trump. Beautiful. Last fall, on behalf of the Attorney General and other federal government defendants, the DOJ, when they're not prosecuting Trump, they argued that the DC Circuit precedent in DC provides that courts lack jurisdiction to review day-to-day White House records management decisions under the Presidential Records Act. So there's other case law that says that, right? You don't have jurisdiction. They've charged them anyways. There was this case called Poindexter. During the Poindexter litigation, Mr. Reagan's personal attorneys and the DOJ, they repeatedly asserted that Reagan's diaries, okay, that contained classified information, he was writing in there a lot, were Mr. Reagan's personal property. Sorry, they're his, okay? They're his diaries. That's what the president needs to do his job. The president has root power to the writings of his executive branch. It's in the Constitution, and so he can do something with that, right? If you don't like that, elect a different president who you have more trust with, right? We like to trust our presidents, even if MSNBC does not. So even though it is possible that the department lacked knowledge of all the facts about how Reagan stored his diaries, officials knew that Reagan contained classified information and that Reagan was treating them as personal records. And it appears that no one ever asked how the diaries were stored or ever made efforts to recover them. Well, that was a long time ago when we had a sane country. So during congressional testimony in March 2023, Jay Bosanko, NARA's COO at the time, oh gosh, can you imagine being a NARA COO? What a job. God. He testified in front of Congress somewhere. He said, if our general counsel were sitting next to me, he would tell me that I should defer to the president with respect to the implementation of the PRA. Obviously. In other words, as expected and accepted, inferior officers lawmakers did not challenge the president's handling of the classified information because they can't. That's why. Now, DOJ attorneys acting on behalf of NARA, they also pressed these points in a prior case in the Judicial Watch case involving Bill Clinton. Watch how the DOJ circles the wagons to protect him. There was a nonprofit, Tom Fitton and our friends at Judicial Watch. They sent a Freedom of Information Act request that was seeking 79 recordings that were from Clinton that constituted a verbatim record of President Clinton being the president. And I've read this, I think we've covered this here many years ago, where it was Clinton like actually talking about being president. Like he was doing presidential things that were being recorded. So like they weren't personal, you know, like he wasn't like sitting with Hillary talking about Epstein's Island or whatever, like gosh, you should have been there, it was crazy. You know, nothing like that. It was actually presidential duties. And so you'd think that those would be presidential records, right? No, sorry. The records contain some of the same types of information that the special counsel's office, they claim constitutes national defense information in this case. Yeah. So apparently back in Clinton's sock drawer tapes, there were foreign policy decisions like the United States military involvement in Haiti. Oh yeah. You mean when the Clinton Foundation went down there and did Lord knows what with all those people? Yeah. So he took those records, foreign policy decisions with Haiti. Clinton and his side of the telephone conversations with foreign leaders. He kept those. Like that's all him being president. And you know, Haiti, I think the earthquake down there was way after they were president, but very curious. Anyways, Clinton, his side of telephone conversations with Secretary of State Warren Christopher. This was about diplomatic impasses in Bosnia. Okay, like presidential actions, clearly. And details from technical forecasts that he received during presidential briefings. And guess what? In response to the FOIA, so Judicial Watch comes in there. They say, we need all those materials. We should get them. Clinton's a corrupt, you know, philanderer. We need to see these materials. FOIA, give it to us. They're presidential records. Let us see. In the request, NARA responded. NARA took the position they didn't even review the recordings, all right? That the requested materials, they just called them personal records of Clinton. Sorry, he defined them that way under the PRA. And that's in a letter. Now, NARA relied on the definition of personal records under the law. The definition excludes the functional equivalent of a diary or journal that was prepared or utilized or circulated or communicated in the course of transacting government business. So they say, it's interesting here, okay? That exception, it is clear that Clinton's recordings did not meet that definition based on the Judicial Watch pleadings and based on Taylor Branch's, shout out, related book about the recordings titled The Clinton Tapes, Wrestling History with the President, published in 2009. But nevertheless, even though they tried to fit it into that exception, neither the government nor the court demonstrated any interest in disputing that position. They don't care. They're like, look, this is back, you know, some time ago. They say, this is the president you're talking about. We're not going to get in there and just decide what to do with this. Like the judge is not the president, okay? NARA is not the president. You have to be insane to just say, we're just going to just topsy-turvy the whole thing. Now, in contrast to this approach of the DOJ and NARA in this case, right, things have reversed because it's Trump. There was no claimed rush to conduct classification reviews or a damage assessment. What did Trump take? What? They freaked out. Now, despite the apparently sensitive nature of the recordings that contain classified materials, it was beyond the imagination of those government employees that the recordings could or should be recovered through a subpoena and a search warrant. Bill Clinton didn't have his house raided, and they didn't go through Hillary's underwear drawer, which saved a lot of FBI agents many years of therapy. But rather, citing Armstrong, they've totally reversed themselves, okay? They would not go after Clinton at all. They wouldn't even think about it. Are you nuts? Judicial Watch, you want access to his record? Get the hell out of here. You guys crazy? But when Trump does it, it's like, whoa, we better call the FBI. Rather, citing Armstrong, the DOJ and NARA, they argued that courts cannot directly review a president's compliance with the Presidential Records Act. Weird. How come they can do it now all of a sudden? The government's conclusion followed from a fact that is essentially dispositive here. They say the Presidential Records Act contains no provision compelling the archivist to assume responsibility for or to review that the president properly categorized and filed separately his personal records. So they did that voluntarily, essentially. They went after the Trump records sua sponte on their own volition. Now, the DOJ and NARA, they also invoked policy considerations to support their non-reviewability argument by asserting that Congress gave each president complete control over his personal papers. Yeah, otherwise, someone else is in charge, in order to encourage presidents to keep and preserve those papers. Many hoped that presidents would later voluntarily donate those papers to the National Archives. Now, Congress was extremely concerned about future presidents and their privacy rights until they raided Trump. Like, well, obstruction. They said judicial review would be extremely intrusive, and such review would undoubtedly discourage presidents from creating any records in the first place. Now, at oral arguments, the court asserted back during a prior case that the law seems to vest, the court said this, right, in DC, the court seems to vest exclusive authority for saying this is personal on the president, which is the person who would know. That's what the court said. So the president is the only one who would know, the only one with the power, and the only person who can make a decision about it. In a written opinion that we have read, the court expressed serious doubts about whether former presidents and their retention of the audio tapes is a personal matter that is subject to judicial review. The judge, when she was reviewing Clinton, said, I can't even make a decision. If he says they're personal, they're personal. We can't look at it and make a different decision. Sorry. And they resolved the case on the basis that these claims were not redressable. So Judicial Watch can't get the records because they're not accessible. They're personal. Clinton said so. Now, as relevant here, the court, NARA, and the DOJ attorneys that represented NARA, they found it extraordinary and unfounded for Judicial Watch to suggest that the recordings could be recovered from President Clinton. They're like, what? It's the president. Get out of here. That was Clinton. It wasn't Trump. So the court, they say, should preclude Jack and his office from further contradicting their prior positions. They already took these positions back in the Crew case and the Judicial Watch case. And so this all must be dismissed because they alleged inaccurately that Trump's possession of the records were unauthorized. No, it was not. And this indictment is impermissible judicial review of Trump's designation decisions. And they'll say, well, Trump never filled out the form, or Trump never talked to Deb about any of this and never gave an order to specifically move these things out of one location into another location. And Trump is just going to respond and say, I had no obligation to do any of that. They're my records. Sorry, you guys already decided this in Clinton's case. They also say the Presidential Records Act recovery mechanism, okay, even if there was some sort of a problem or confusion with the Presidential Records Act and the president's sole discretion to declare the documents as personal, even if there was a problem, it's not a criminal problem. In February 2022, a NARA official informed the FBI that NARA had never made a referral to the DOJ. Isn't that interesting? Never. Yeah, and that's after Trump was out of office, obviously. So NARA says, well, hey, FBI, it's kind of our first time. Wondering if you can help us out with this. Like, sure, what can we help you with? Well, we want to go after Trump. FBI is excited as can be, like popping out of a jack-in-the-box. We can help you with that, right? They're ready to go. The history is entirely consistent with the absence of both criminal investigative tools and criminal penalties in the PRA, because they've never done it except for Trump. Now, here, there are other cases being cited, but they say, look, given the PRA's limitations, as acknowledged by NARA's historical practices, even the NARA OIG lacked reasonable grounds to believe that there had been a violation of federal criminal law when it transmitted this sham referral to the DOJ on February 9th. So even NARA's Office of Inspector General said, well, we think we lack reasonable grounds to believe there was a crime. But NARA said, we don't care. We just need a pretext to go prosecute Trump. NARA's purported referral to DOJ prosecutors was therefore improper, and it was not foreseeable to President Trump given NARA's historical practices, right? This is a notice problem. You're saying that Trump was following the same code of conduct, the same course and manner of the law as everybody else, and now it's a crime? That is like creating a new law, right? And so Trump didn't have proper notice about what conduct was permissible and not. And so now it's like you just passed a law to prosecute him specifically, and that is not allowed under our Constitution. Now, because the referral was improper, there was no basis for the FBI to predicate an entire investigation on it. And so consequently, Trump's team continues. They say the obstruction and the false statement allegations that come from count 32 and 42, the first 32 counts are the documents. Okay, but Trump is allowed to have the documents because they're personal records. So therefore, if he's allowed to have them, the obstruction and the conspiracy charges, those also got to go. Saying, as the DOJ said in the prior Judicial Watch case, they said that the alleged violator here is a former president of the United States. They were talking about Clinton, we love him. When enacting the PRA, Congress was keenly aware of the stark separation of powers questions implicated by legislation regulating the conduct of the president's daily operations. That's the DOJ's own quote, right? Now they're saying Trump has to check every book out with a library slip and turn it back in by Thursday, whatever. To the extent NARA seeks to recover what are now properly designated presidential records from any third party, including a former president, the PRA provides the exclusive means for doing so, if that even is a thing, even if these are presidential records and not personal. The only way you get them back is with civil remedies rather than a criminal prosecution. But they had to create a new criminal charge against Trump. The FBI guidelines also require that to properly predicate a preliminary or full investigations, an activity constituting a federal crime, you got to have information related to the activity there, and that's from the DOJ guidelines. So they say, continuing, specifically, when there is a problem, if the Presidential Records Act needs needs to go get some records, the PRA authorizes NARA to invoke the same enforcement mechanisms that's in another part of the code called the Federal Records Act. And the Federal Records Act, it establishes the only one remedy for the improper removal of a record from the agency. One way to get them back. And Congress opted in favor of a system of administrative standards and enforcement. Now, the process begins with a request to the Attorney General to institute an action for the recovery of the missing records. Now, in response to a NARA request, the Attorney General then may pursue recovery via replevin, which is the returning of property, right? Here, replevin action related to a map annotated by Kennedy during a Cuban Missile Crisis. They went and got that back. Now, tellingly, it is precisely what the DOJ did in response to the portion of the February 9th sham referral from the NARA OIG that did not relate to President Trump. Okay, so there were other documents. In an effort to recover those other records, the DOJ initiated a replevin action rather than a criminal investigation, grand juries and search warrants. They saved all that for Trump. So there are other incidents where they go get him back in different manner, and they just raided Trump. Now, in Armstrong 2, the DC Circuit went even further, and they suggested that neither the archivist nor an agency head can initiate any action through the Attorney General to effect recovery of the presidential records. Like, you can't get them. This is the DC Circuit saying this. Compare the US Code and other codes. But anyways, more footnotes there with more details. Now, Trump's defense continues saying, according to a brief filed by the DOJ and the National Archives in Judicial Watch. So again, years ago with Clinton, Judicial Watch is trying to pierce this to get access. NARA and the DOJ says, get out of here. They both said this responding. They said, this administrative enforcement scheme is exclusive, and courts may not order the recovery or the retrieval of records that may have been removed or destroyed, which is weird because they got a search warrant for Trump. So why did the judge in Florida author a search warrant if even the DOJ and NARA admit that courts may not order the recovery or the retrieval of records? They admitted that in a prior filing, in a brief. Now, the PRA does not require NARA to physically seize presidential records, but instead it relies upon a much more limited and a sensible administrative enforcement scheme. The Judicial Watch court, when they were reviewing that case with Clinton, they observed that. They said, quote, because the Clinton recordings are not physically in the government's possession, NARA would be required to go seize them directly from Clinton. I mean, they did that with Trump, and NARA considered such a seizure to be an extraordinary request that is unfounded and contrary to the express terms. The DOJ made similar assertions when they were in oral arguments. The judge was asking the DOJ questions when they were trying to protect Clinton. The judge said, hey, government lawyer, let's say a president kind of maliciously overclassifies, as presidential records to avoid a FOIA. What is the remedy? Overclassifies. Like, what if they, put them one way or another so they can't get them? And they said, well, Your Honor, if the president classifies it, the first one and the primary remedy is that it always lies with the archivist and the Attorney General, who have the authority, if they believe the president has misclassified something, that they can invoke the discretionary enforcement mechanism and they can pursue the recovery of those records civilly. Now, the DOJ characterized recourse to the PRA's discretionary enforcement mechanism as a very serious step for them to take, and noted, if Congress believes that the president is wildly misclassifying information, it can pass a law to change the structure and they can seize those records. Now, Congress has not done so, leaving in place this civil recovery mechanism as NARA's exclusive enforcement option under the PRA. And again, I challenge a lot of that. Again, these are the executive's documents at root. And Congress, in my opinion, if they wanted to take control over all of that, they'd have to amend the Constitution on certain categories here. So anyways, Congress, they say, they know that explicit language is required to rebut the exclusivity default. For example, there's a pending bill that would add a civil enforcement option, and so on. Now, in conclusion, Trump's defense wraps this up, and I like this argument. They say, for the foregoing reasons, President Trump respectfully submits that the court should dismiss this entire indictment, the entire classified documents case, gotta go, based on the Presidential Records Act. Another great filing, part of a massive motion to dismiss drop from the Trump team, and we're going to be covering all of these motion to dismiss filings that have come out, and this is one of many. But this is a big one, okay? And the double standard here abounds. You can see it clear as day. Bill Clinton, as the president, has the power to do those things. Now, you might think that that was inappropriate of him to do what he did and classify a bunch of stuff that he kept in his sock drawer. Maybe I would agree with you, but he's the president, and that is the president's right. If you say, sorry, anybody can just declare that discretion usurps the presidential discretion, that makes you the president, and it takes away the power of that position. And that is how you invert the whole constitutional order when the president is clearly the executive of the executive branch. It doesn't work if you subordinate him to someone else who doesn't have the lawful power. What happens? We're living through it. We're watching what happens when they they invert all of this. They start prosecuting their political enemies. They pat themselves on the back like they did a good job. But the case precedent shows us clear distinction, even in DC's own circuit, between presidential and personal. And the idea that Trump took the documents or he didn't fill out a form is not dispositive, right? Clinton didn't turn his materials to the archives. By default, they automatically then become personal records, not subject to review. Trump did the exact same thing using the same precedent, and they created and concocted a crime out of it in a way that they've never done historically. This calls it out, and we're not in Judge Chutkan's courtroom. We're now in Judge Cannon's courtroom. And when this comes up for oral arguments, we can't wait to hear what Jack Smith and his deranged thugs, including Jay Bratt, say and how they try to defend this. We had a little bit of an update from CNN. They were sharing with us some of Trump's plan to use these two cases against one another to gain an advantage in the trial calendars moving forward. And this is an excerpt from CNN explaining how these trials are going to be unfolding here very soon.
John, Donald Trump doesn't want to go to trial. That's not new, but
I kind of think that he does, but when it's appropriate. He doesn't want to race to trial when they're trying to squeeze through 12 million, 13 million pages of discovery down his gullet without even the opportunity to read it. So we'd like a fair trial, not a rigged trial that was conducted and colluded to be executed before the election began.
The strategy that he is going to be employing through his lawyers does appear to be something we're going to see play out in the coming days. So right now, Trump is set to go to trial in New York in his hush money case at the end of March. That will block out the calendar for him to be in trial as a criminal defendant late March to about mid-May. Then the calendar's open after that, and there are two federal cases that are vying for
Florida,
the possible
J6
places on that calendar. There's the possibility that that January 6th case in Washington, D.C. could get back into the hands of the trial court and could be headed to trial. And then, of course, his Florida documents case. But just this week, his lawyers are headed into a really crucial hearing in that Florida documents case before Judge Eileen Cannon. They have a trial set for the end of May. It's very likely that that's going to get moved. So what they want to do is move it just a little bit, just a month or two into July. And then the possibility could arise, because that case is so complicated with classified documents, that it might have to move again. So it would essentially elbow out any other trial if it just has a place in the calendar and gets moved along through the summer. So Trump would achieve his ultimate goal of not going to trial before the election.
Which means that Jack Smith would fail his goal. It's Jack's goal. It's not Trump's goal. Okay, he didn't prosecute himself, weird people at CNN. That's you guys. And so Trump now just wants some due process, just wants equal protection under the law, wants to be able to flesh out each one of these issues, because a defendant deserves a right to a fair trial, not one that is being conducted by an illegally non-appointed deranged thug like Jack Smith, who's not even U.S. attorney, in order to take out their political opponents in the middle of an election. And so, my friends, we're here, we're covering this one. We've got a few more motions to dismiss coming down the pike. And so thanks for subscribing and joining us as we continue our coverage here, not only of the classified documents case, but all of the rest of the Trump prosecutions and ballot removal litigation and SCOTUS appeals and the rest of them. And so we'll be here, my friends. Thanks for joining us as we do, and we'll see you right back here on the next one.